After an accident, minutes matter. Your words and actions matter even more. You need help, and you need it now. This is David versus Goliath, brought to you by Dolman Law Group Accident Injury Lawyers, a boutique firm with a reputation for going head-to-head with the insurance company giants and putting people over profits.
Welcome to another edition of the David and Goliath podcast. Here with my business partner in crime, Stanley Gipe, and we have an esteemed guest today, Marcus Susen from the Susen Law Firm. So Marcus is kind of a quasi-hero of mine. He just got on the steering committee in Ozempic, which is an interesting story we can't get too much into for a lot of different reasons, but it's this is an exciting mass tort that's just kicking off now. And then during the same podcast, I want to talk about a more mature mass tort. The product's been going on for quite a while that Marcus is in leadership on as well, which is Paragard, and that's an intrauterine device. And Marcus has a lot of experience in that, being that he's former co-lead counsel on eSure, which is where he really broke his teeth in this business, and really that was his first leadership position. So, Marcus, thanks for coming on. I really appreciate it.
Yeah, no problem. I guess it's just, I'd like to say it's sad that all three of those torts that you just mentioned are all aimed towards women. It's the one thing that just came to my head.
Yeah, well, take us through that. So, you know what? Before we get into the more sexy mass tort, if you will, just because it's so exciting that it's a big manufacturer in Novo Nordisk, and then also Eli Lilly and their version, which is Mounjaro, of these GLP-1 medications. Let's start out with intrauterine devices, kind of an explanation, an overview, if you will. And there was a few of these that failed before, namely Mirena back in, I think it was 2014-15. That one got kicked out on Daubert. Then I know that you got the eSure leadership. Tell us how that took off, because you basically, if I remember this correctly, and I shouldn't even say like I know the story cold. I'm just rather you tell the audience, but you took a mass tort that was basically dead, a product that was completely dead, and revived and brought it back to life, and that was eSure. Take us through eSure, and then take us through Paragard.
Yeah, so starting off with what you mentioned earlier, it goes before eSure. I mean, you can go all the way back to the Dolman Shield, which is a case that we all learned about in law school.
By the way, Stan feels really good about himself because he just brought up Dolman Shield downstairs. Stan, there's a brownie point, Stan.
There you
See,
go.
when we were talking about this and he was saying IUDs, I'm like, what was that original one that like started everything off? And it was, the Dolman Shield. I can remember this, like, just looking and going, oh my God, these things are manufactured for pennies. And you look at this, just a little piece of plastic. How do they get this wrong? Anyway, go ahead.
Yeah, and it's when I went to the FDA to meet with the commissioner at FDA a few years ago, they actually I saw a Dolman Shield was actually in their display case, trying to say they did something well with pulling it. But yeah, it goes back, and again, it's sad because all the birth controls primarily all of them are aimed at women, which come with risks. Every birth control device or drug has risks, and unfortunately all women bear the brunt of all those risks. But, for eSure, as you mentioned earlier, Matt, that was a case that it was a permanent sterilization device, and really no firm wanted to take on that case initially because of a legal issue called preemption, something that we'll hear about a little later with Ozempic as well. But through a few years of litigation, actually in the same court that Ozempic is in, the Eastern District of Pennsylvania, we were able to get over that hurdle. eSure subsequently got pulled from the market, and the case resolved.
So what happened in that case? Take us through preemption. I mean, I know what preemption is. I believe Stan has a grasp of it. Just for the audience out there, what's the FDA's role? What is preemption, and how does that interplay with the warning label and the change of the warning label?
Yeah, so preemption is I mean, we could talk for weeks on the issue of preemption. I mean, there's books, there's treatises, there's law school classes. It took us several years to smoke that issue out with eSure. But essentially, one of the arguments with preemption, there's different kinds of preemption. There's express and implied preemption. But one of the issues that we'll see come up in Ozempic is essentially the argument that the defense makes is, hey, look, our hands were tied because we have to go with what the FDA allows us to warn and put on our labels. And therefore, we can't do anything more or anything less than what the FDA is telling us. Therefore, if we miss a warning or we don't warn enough, those claims are quote unquote preempted, and a plaintiff is not able to have their day in court.
Okay, and well, we can start with, if you want, we can start with Ozempic and then work our way back to Paragard, or vice versa. But how does, in Ozempic, for instance, what's the game plan? How do we get around preemption? What's the general? How do they frame these type of issues?
Yeah, well, I think that obviously the defense is going to come and they're going to state that, all our labels and warnings were approved by the FDA. So anything more that you're requiring us to do, our hands are tied and you can't bring a claim for that. The first thing is that representations in warranties are not a subject to preemption. So, for example, if a defendant or big pharma company is making representations or warranties outside of the label, okay, those warranties they're responsible for those. Preemption is not even an issue for those. So that's one. The other aspect of it, which people aren't talking about now, but I'm a big proponent of informed consent. And there's a difference between a warning and a passing reference to a risk, maybe in the adverse events section, right? There's a complete difference between a warning and, this may cause this, buried down somewhere deeper in the labeling. Now, if the issue I think in Ozempic is going to be and these get over preemption, are those legit warnings adequate, right? Are they adequate?
Okay.
And if they are adequate, did their overpromotion, their warranties nullify an otherwise adequate warning? If you're with me so far, it gets very confusing. But
No, I follow.
yeah, I mean, you can't hide behind my warning says A and therefore I'm protected, but at the same time go out and be marketing saying B and C. Because those representations can nullify an otherwise adequate warning. So that's one aspect of it.
Are you talking about like off-label use where, hey, we'll have a drug or something that's approved for one use and then a company begins to sort of market it for a slightly different use than it's originally intended? Or are you talking about something else?
I'm talking about something else, but that off-label use is another way to get around preemption. That's kind of like a different bucket, but that is another way to get around preemption. And another aspect of it is not just a failure to warn the plaintiffs and their doctors, but there's also what they call people refer to it in the legal world as a Stengel claim. It's a failure to warn a third party. And here, that third party is with the FDA. Those claims aren't preempted. Now, we have to find and prove that these adverse events weren't being reported to the FDA. And that's something that will come out in discovery.
So
Gotcha.
who has the responsibility for reporting these adverse events to the FDA in the first place?
The manufacturers of the products have the responsibility too. Doctors should, patients should, but I guarantee you if something bad happens, when was the last time you talked to someone and said, I was sick because of this drug or I was injured, so I went on the FDA's website and filed an adverse event report. People just don't know about it. Doctors very rarely use it. And in fact, on the FDA's website, they acknowledge that 1 to 10% of adverse events out of the whole picture will actually get reported. So for example, in Ozempic, there's currently about 11,000 adverse event reports. And we know that 1 to 10% of those complaints are getting reported. So if you extrapolate from that data, we're really at 100,000. It's just that people don't have the knowledge and they don't report to the FDA. So, 100,000 complaints is nothing to blink at by any means.
No, of course not. Stan looked like he had a question
I'm
before I was
sitting
going
here going, when you bring it up, I consider myself a relatively sophisticated person. I'm a practicing attorney. I can file stuff in court. I can do all these things and try cases. I wouldn't know how to go about reporting an adverse event to the FDA from a drug. And honestly, as I sit here, I really, you're just now bringing it to my light. That might even be my responsibility. I would just assume that your treating doctor, your prescribing physician, whoever it is going to be most familiar and have the avenue to go report that.
Yeah, I mean, your doctor should be doing it, but let's all just take a minute, right? Picture ourselves going into the last doctor that we went into, right? Your primary care physician. Let's picture ourselves going in there and you were just on a drug and you tell the doctor, I've been experiencing A. The doctor, do you think he's going to take time, he or she is going to take time to go and fill
No,
out an adverse event report?
absolutely not.
Maybe
They're
some
getting
doctors would, but that's why there's a huge underreporting problem in these adverse event reports, even though there's 11,000 filed, are extremely skewed.
Yeah, I mean, very few doctors that I've gone to, and I may have a different experience, have any extra time, right? I'm usually sitting waiting in the waiting room. They're taking long. There's 3 people waiting behind me. And, I don't see my doctor taking time out after seeing 10 patients telling these other guys, you got to wait another 5 or 10 minutes while I report something to the FDA. And he's not benefiting from it financially, and in fact it's a detriment to him because he's taking time where he could be billing patients, and now he's got to report this and do something that's really a non-billable time.
And in something like Ozempic, it's actually for these physicians that specialize probably in weight loss or using this medication or prescribing this medication off label. It would certainly be a detriment and impediment to them being able to make a profit in their business. So let's start with Ozempic. So Ozempic, Mounjaro, Wegovy, I think Trulicity and Rebellos, those all got consolidated in the Eastern District of Pennsylvania in front of Judge Prater. And I know that case is just kicking off. And I saw just yesterday an article from I think it was Harris Martin had it that there's now a science day being scheduled in front of Judge Prater for I believe June. What is a science day? If you could explain to the audience, and then let's get into the meat and potatoes of the science of this case and how do we show that GLP-1 medications cause gastroparesis, which stomach paralysis, or ileus, or intestinal blockage. I think there is a warning label for intestinal blockage, but not for the other two. And, where do we stand with this? But let's start with Science Day.
Yeah, so a science day is intended to educate the court really about the science behind very complex drugs and medical devices. And I mean, I got to give judges and courts all the credit in the world because these judges, I mean, if you think about it, they have to sit through criminal dockets and be experts on that. They have to sit through civil trials, complex securities, patents, and now, the class actions, and now they got to become experts in drugs. So a science day is really just kind of an opportunity for both sides to present what is supposed to be, an unbiased presentation of the science of how the drugs work, what they can cause injury wise, the FDA approval process, and things like that.
So do both parties proffer up experts? I know they can't be questioned by the lawyers, but does a judge get to question actual experts in the case, or?
Yeah, so it'll be very similar, kind of like to oral argument in the Supreme Court, right? You'll have some judges that'll have their head down and sleep, or they'll have some judges that'll be more proactive. So during science days, judges, I mean, clearly can do whatever they want. And the ones that I've been involved with, the judges have had a lot of questions. Sometimes, most of the time, they do have experts. However, in this case, we're just going to be the science is going to be presented both sides by an attorney. So there will be no consultants or experts presenting it at a science day, at least for this tort. But the majority of them.
It's so early in this mass tort.
Oh yeah, it's extremely early. Extremely early. I mean, it's a very hot topic. The drug is all over the news. I'm sure everyone has heard about it.
Of course.
People are saying it's the next best thing. But, I always like to say, slow down. Everybody slow down, right? Every drug that's been approved by the FDA, or excuse me, every drug that's been recalled by the FDA was first approved by the FDA, right? And then, I mean, I'm not comparing this to opioids by any means, but when the opioids came out, it was a miracle drug, right? It was non-addictive. It was a miracle drug. And we saw what happened there. So everyone just needs to slow down. And again, I always revert back to informed consent, having all the risks, yourself, your doctor, but not only you guys and gals, but also making sure that the FDA knows about all the adverse events. Because if the FDA doesn't know about the adverse events, then guess what? No updates on warnings, potentially no informed consent if they don't have the warnings. So it's extremely important.
So in this case, I guess where do we stand before we get into the science on Ozempic and the other GLP-1 medications and stomach issues? I guess I wouldn't call it dissent among this steering committee, but more of I know one firm, Motley Rice, was looking at the gallbladder issues and gallbladder stones and gallbladder removal. Is that something that's being considered by everyone, or is that just something is like a one-off that one law firm's kind of focused on? And what's the science there, or is that you just want to focus on the stomach issues?
Yeah, well, I mean, it's really all going to come down on the preemption argument. We know, unlike a Zantac case or a Tylenol case where the issue was, does this drug cause this disease, right? And they run into a Daubert issues there. I don't think that's what this case is about. I mean, it's pretty clear, at least from my view anyway, that this drug can cause gastroparesis, can cause ileus, can cause gallbladder issues, right? It's more going to be about a failure to warn preemption type of argument from that perspective.
So general causation, you think, is going to be pretty simple in this case. When for the audience who might not understand that, general causation is, does X cause Y, and in specific causation is more of, did the individual A use of X cause them to develop Y? Is this a general causation or more of a specific causation issue?
I mean, in this case, I don't see general causation being that big of a hurdle. I mean, you saw the FDA come out and have them require to put ileus at least on an adverse reaction, right? So the FDA is telling you to do something, means it causes it, right? Same thing with the gallbladder issue, which you raised earlier, Matt, and I'll get back to that. But same thing with the gallbladder. In 2022, they updated their warnings, at least Ozempic and Rybelsus did, to include warnings about gallbladder. So, I mean, if you took the drug before that time period and you didn't have that warning, now whether that warning's adequate is a whole different story. But if you were before that time and you had a gallbladder issue, I don't think causation is going to be that big of an issue because later down the line, they put it on the warning. I think the only one that really pops out to in my head right now that could have a Daubert issue is thyroid cancer. The FDA has on their website, and it's known that semaglutide, which is the active ingredient in Novo's products, can cause thyroid cancer in rats and mice. Now, does it cause that in humans? They don't know. The FDA doesn't know, right? There's no connection there just yet. Could there be? We'll have to see if the science develops. That could be a Daubert issue, which is strange because they put that in the black box. They have a warning about the semaglutide can cause those thyroid tumors in rats. They don't know if it causes in humans, in rats, but let's tell people about that. It's just, I don't understand why they warn about that if they're not sure it causes in humans and they don't warn about the other things.
So we're pretty deep down the rabbit hole talking about this, but we've kind of bounced between IUDs and now we're talking about Ozempic and different drugs. I'm not sure everyone is going to be familiar with what's going on with the GLP-1 drugs and Ozempic. Maybe just explain how those are being used and what's going on.
Yeah, so GLP-1, the way I think of it, I mean, I like to dumb things down, not necessarily for the audience, but for myself. I just like to dumb things down for myself. And I think of a GLP-1 as a synthetic hunger hormone. That's what the way I think of it. It's a synthetic hunger hormone that stimulates insulin production, hence the diabetes, and suppresses or slows the gastric emptying, which helps with the weight loss. So that's essentially how that product works. And now, which started off as a diabetes drug, is now coming to a weight loss with a comorbidity drug that we all know about now. And one of the biggest problems that I see with it becoming a weight loss drug, and I hate to get off topic, but the thing that's really kind of grinding my gears right now is seeing all the telemed appointments and talking to clients about them getting prescribed a medication over a telemed appointment very easily.
I did.
There you go.
Marcus, when I had my foot surgery, I didn't want to get, I'm already a fat little munchkin, but I didn't want to get too much fatter, and if that's a proper English. So I didn't want to put on too much weight when I was living a sedentary lifestyle because I just had my foot up and I couldn't walk around. And I remember I got on Mounjaro and it was just telemed. They really didn't even ask me any questions. It was almost like rubber stamped. I just told them I was slightly obese. No one checked me. In fact, there was no actual screen share. They didn't even see me. It was just I just typed out an email and they responded. And next thing you know, I had a prescription for Mounjaro. I was doing it for myself and in my house, and before that in my office. And then it was no big deal.
Yeah, that's the part that scares me. I've talked to numerous clients that, it takes 5 minutes. They can do it from their couch. They get a prescription, right? It's easy. Type on, boom, they respond right away. These same people have started to develop problems, and they go back to the telemed and they say, hey, I'm dealing with this. Radio silence. Nothing. And then they go back and they say, just to see if they can get their attention, they say, oh, I want another prescription. Boom, they respond immediately. That is very scary. I've talked to numerous clients that had that same problem. They ask for prescription, they answer right away. They have problems, they go back to that same doctor and say, hey, I'm experiencing this. What should I do? Radio silence. But then to get them back to respond, all it takes is, hey, I want another prescription. And then boom, they got their attention again. That to me is terrifying. Whether that is related to the defendant's conduct, we'll have to wait and see. We know that Novo Nordisk has Noom, has a relation with Noom, which is a telemed. We know that Eli Lilly just partnered with Amazon for a telemed. So that to me is very, very concerning, just from a public health standpoint, not necessarily from a defendant's liability standpoint. But again, I hate going back because they're different drugs than comparing it to the opioid crisis. But
No, but I get your point, though.
we saw that with the pill mills, right? You walk in, you say, I got pain, here you go. Those same people go back and say, I'm addicted. They get pushed off to the side. And, it's not the same drug.
Stan, you go first. I
I was
apologize.
going to say, I think this is almost the exact same thing, right? Okay, so you go into the opioids. There is probably a 2 to 5% of people out there dealing with massive pain from cancers and things like that need high dose Oxycontin regardless, right? It's great. Then you've got the other people out there with some light pain, what I'd call some pain management, but not true massive medical pain management, right? When we're dealing with these weight loss drugs, you've got some people that have what I would call medical obesity. Like I've got problems with the way my body works because of I'm obese, my body mass index. That's what I call medical obesity. And that's, I think you really look at the risk. Hey, I need to do something because my body's going down. This is more used for what I would call aesthetic obesity. It's not people that are out there going, I'm having medical issues due to my size. It's going, I want to look better. I want to be thinner. I want to be aesthetically pleasing to the public as opposed to being healthy. And I think what you do is when sometimes the pursuit of aesthetic weight loss as opposed to healthy weight loss leads to some real problems, and these drugs get overprescribed.
Yeah, and you know what? The questions, I mean, you see Oprah, I don't know if you caught her special on Ozempic, which was a bunch of paid endorsers for the drug companies, but it sounds like
All shills, yeah.
Yeah, I mean, I watched that and I was like, wow, this is a miracle drug, right? A colleague
Well,
of
anyone
mine
who's listening to Oprah to get advice about obesity, the woman yo-yos more than anyone I've ever seen. She's fat, skinny. Not shaming anyone, but she never seems to stay consistent. That's what I don't understand. This is a question I want to ask you here. So, Stan, for instance, he's on leadership in Suboxone, and you'll see the parallel in a second. So, the argument that we anticipate in Suboxone is that they're going to come back, NVIDIA, the manufacturer, and say, well, yes, this definitely caused tooth decay, but what was the alternative? Is you were going to stay on opioids, and this is the frontline gold standard for opioid addiction treatment. The individuals who are taking Ozempic, Mounjaro, Wegovy, Rebellos, Trulicity, and whatever other GLP-1 medications, I would assume, and I don't know this for certain, but I'm sure their blood markers have definitely improved as they've lost weight. They are now healthier. And the alternative was they could have stayed, I know this is off-label use, but they could have stayed very unhealthy, and not saying this turned them into, a healthy specimen, but it definitely improved them, as proven by blood biomarkers. Is that an argument that you anticipate that Eli Lilly and Novo Nordisk, their lawyers, are going to bring forth and say, we actually greatly improved their lives? Yes, they were injured. Very few of them required surgical intervention. It was a temporary issue that they had to overcome, but they still are much better off having used it? Or, I mean, what is there going to be their arguments?
I mean, absolutely. I mean, we've already seen it in the court filings that, even not just in the court filings, but on TV, this is a miracle drug. This is going to help everybody. Obesity is a big epidemic, and I agree. And there's good drugs and there's bad drugs, and there are good drugs for certain people, but those same good drugs could be a bad drug for that same person. And the questions that, no one's really asking about is, well, what happens when you stop? And you mentioned Oprah. What happens when you stop taking the medication? Do you gain the weight back?
I want to ask you that question. Yeah, yeah.
And if you gain the weight back, are you gaining the muscle back? Or are you gaining the fat back? And therefore, if you gain the fat back and not the muscle, are you really left in a worse state than you started? So do you have to take this drug? Are these people going to have to take the drug for a synthetic hormone for the rest of their life? Are they eventually, their body's going to build up a tolerance? So you're going to have to keep increasing your dosage? And then what's the highest dose you can get to? These are questions that, Oprah's not asking, that no one's really talking about, because all they want to do is, us as a society, we like thinking short term. Everything's in 10-second bites, and everything
No,
is
it's a
now.
great. I didn't think about that. I mean, I started at 2.5 milligrams, and I had to work my way up to 10 because your body gets used to it. I remember Julie, and we can speak open. We're on a podcast right now. My one bad vice is I smoke weed. I do every day. So what? Judge me. And she would make brownies. My kids would, they were all over it. And I'd be sitting there. I'm like, nah, no. She's like, what are you on? I'm like, don't worry about it. I'm on Mounjaro right now. Then all of a sudden a week goes by, 2 weeks go by, and all of a sudden I'm ready to eat that again. And then I have to go up to 5 milligrams, and then 7.5, and then 10. And then where does it stop?
Exactly.
Your body is going to get used to that.
Yeah, where does it stop?
Crazy.
And if you increase it to a certain point, do those risks go up? Is there a warning about that? Do they warn patients, hey, look, when you go
Well,
on
that's the question. Is it dose dependent? Does the risk go up as you take more?
Exactly. And that's what we'll find out. But I mean, the more drug you put into someone, the more reaction it's going to have. You're putting a synthetic hormone into your body. And that's why you begin dosing small and move up.
And I think what you're talking about is just in the companies in general try to do this greater good argument. Hey, society overall is better off for this having been out here, so ignore the problems. But as you say, everyone interacts with drugs differently. Everyone has different experiences. Individuals may have problems. That's why they put warning labels out there. And I really think that the function of the warning label is almost twofold, right? One, to let you know what may happen, but the second fold, and I think it's almost the most important thing, is once you have a problem, hey, like for Suboxone, right? If your teeth are rotting, you would never know unless you looked at, if there's no warning on the Suboxone label, you wouldn't know that that's what's causing it. No reason to use it, no reason to adjust your use, and therefore it explodes. So it's not even, I don't think, just a proactive thing. It's reactive. Hey, once someone realizes a problem, hey, why am I having these headaches? Let me read this drug I'm taking, see if it causes headaches, right? And if it doesn't say it, well, then this must not be it. I got to find something else, right? So it's that kind of thing. It doesn't give someone who, even if they did say, hey, I'm addicted to drugs and I need Suboxone, it doesn't give them the opportunity to sort of remedy or fix the problem because they don't know what's causing it, right? It's like you can't fix it if the cause hadn't been identified. So I think that's the big problem out there.
I couldn't agree more with that, Stan. I mean, and I'll take it a step further. And we saw in the Esher case when women were dealing with problems, they go to their doctors, and the doctors wouldn't know. But what does that all come back to? It all comes back to the FDA needs to be fully informed by the doctors, by Big Pharma, and including by us, by the patients. I mean, I can't praise and tell people to do it enough. Is if you experience a problem with any drug or medical device, go on the FDA's website and file an adverse event report. Because if the FDA doesn't have that information, it affects everybody. But you're absolutely right, Stan.
And it's incumbent upon the manufacturer to do supposedly all this testing before the drug gets released. They're supposed to look, they're supposed to test in sufficient numbers that they can see the trends and see these causes. And they're supposed to be reporting this to the FDA well before the drug gets approved. right? So sometimes they sneak one past the goalie. Sometimes you may find that there's certain things that showed up that they didn't maybe prominently focus on or present in the right way. And, suddenly the public is out there a la cigarettes, right? Reporting all these things. And turns out this company may have, whether they had actual knowledge, they may have had willful ignorance.
Yeah.
Good point.
And I've seen it before in a lot of other cases where, yeah, they study the drugs before they go onto the market. But if you really start digging down into the clinical trials, well, how many people did they lose in the study, right? For various reasons, which skews the data. I mean, it happens all of the time, and that's the thing that terrifies me. And again, I'm not saying that there's some good drugs, there's some bad drugs. I'm a proponent of good drugs and medical devices. They save lives, they keep people alive. It all comes back to we got to do the right thing. We got to keep everybody informed. Because a colleague of mine said this before, and I'm sure both your moms and your dads tell you growing up, if it sounds too good to be true, and it's a miracle, it likely is. I mean, to me, that's why I don't like jumping right to these conclusions. We need to ask these questions, and we really need to dig into the discovery to find out what the company knew or should have known.
So one last question about the Ozempic litigation before we move on to Paragard. The injuries itself, absent the ones that require surgical intervention for like gastroparesis, ones where individual has gastroparesis or they have ileus before the warning label, or some type of intestinal blockage that's not, I guess, ileus, or other stomach-related issues that get better over time that do not require long-term hospital stay. What are the damages in those? Because they're going to be fine. It's not necessarily a permanent injury, or is it? Am I missing the boat here? And I'm not trying to in any way demean those injuries, because that's terrible in and of itself. You have to see a GI doctor, go through a battery of tests to try to figure out what is wrong with you, when most GI doctors are not aware of the science that these GLP-1 medications actually cause gastroparesis. Because I actually saw a doctor because I thought I had gastroparesis, and I may have actually had that, and over time it got better. So the question is, what are the damages, and how do we show it on cases where it's absent surgical intervention, where that's a much more obvious connection?
Yeah, well, I'm just speaking for myself. If someone has vomiting or diarrhea or nausea for a week or two, I wouldn't take that case on.
Mm-hmm.
That is in the warnings that you're going to experience those types of things. What's not in the warnings is, you're going to have your gallbladder removed, or your stomach's going to be paralyzed, or you're going to have the feeding tube in or hospitalized for several days. So I think there's a severity of injuries for sure. If it's just 1 or 2 days, okay, then maybe they warned about vomiting and it was just a short-term result. But if it's a long-term thing that you have to deal with, then there's other things that result. There's secondary injuries. If you're vomiting, guess what happens? Your teeth start to decay. If you're vomiting, guess what happens? Malnutrition, right? And those are the same people that are in the hospital. They have their stomachs are paralyzed. Not only are their stomachs paralyzed, but they have these secondary injuries like malnutrition. Then you get muscle atrophy. It cascades into so many other secondary injuries that, everyone just needs to be aware of the risks that are involved.
And I hope you didn't take this to me, because I knew the answer to that question. Not that I know anywhere near what you know on this topic. I just getting ready for this and having looked at this case, and we've discussed this project offline before multiple times, and I believe in this. I knew that. I think that a lot of individuals need to hear that, though, because the defense from Eli Lilly and from Novo Nordisk and their press releases and what they're putting out there is these injuries are not that serious, and the good outweighs the bad, and just the same usual bullshit that you're always going to hear from drug manufacturers. So to segue, if you will, where do we stand now with Paragard, which is obviously a far more mature mass tort or lawsuit, because that's been around for a while, and I know you're heavy in the trenches in that litigation. What's the latest status on that? Where do we think that ends?
Before you get into that, what is Paragard?
Yeah.
Oh, I apologize. I should have not just take that for granted that people know what Paragard is.
Paragard's an IUD, which is made of essentially copper is the mechanism of action, which is what allegedly prevents sterilization, although no one has really found out how. how does copper prevent sterilization? No one has really figured that out yet, which is crazy to me. But that litigation has been going on for years now. The defendants have recently switched their law firms who represent them. One can infer what happened or maybe what didn't happen as to why they switched law firms so far into a litigation, but it has happened and it has slowed things down. Again, this is defense playbook 101, right? Delay, deny, defend, ask for another signature until everyone just gives up and says, "I'm done with this. I don't need this in my life anymore. It's been going on for 2 years. I give up." That's their playbook. And unfortunately with Paragard, I think we're seeing that, at least the delay aspect of it, pretty well played by the defendants. Now, was it something the defense counsel has done, or is it just a slow play? I don't know at this point, but it is going slow. And I can tell you that just recently we have obtained, thousands and thousands of documents that we have to review, which I wish we would have had a year ago. But again, if anyone has suffered any of those injuries or has a case out there, we cannot give up. It's like talc, right? The bankruptcies, delay, 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 delay. Do as much as you can until these people get lost, they die, or they give up. That's one of their main defenses. And you know what? It works. It works. I'm sure you have seen
it. It does. People get tired.
People get tired. Fatigued. Yep. But
and this is gonna be an odd comment, and I hope you don't take this the wrong way, because it kind of has a pejorative term, because these aren't investments. These are lawsuits, real people with real injuries. But if there was like an underrated mass tort that doesn't get a lot of attention, that I think is going to actually take off over the next probably year and a half, and come in for a very fruitful outcome, it is Paragard. I think the science is there. I think it's a strong case. I think there's some unusual delays in this case that, I mean, I shouldn't call them unusual anymore. We should come to expect these things to happen.
You're right.
Pretty much every project for a myriad of reasons. But I think this is going to come in for a landing. What's the status now in terms of, so you got a document dump. What's next? Are there bellwether trials being set? If so, when? Where are we with science? What's going on in the case?
I'll start off with the easy one. Where are we with science? It's pretty simple. The device breaks, and that breakage causes subsequent surgery or injury. Daubert, like we talked about earlier, general causation, really not an issue. As far as, bellwethers and where we're in the litigation, we as a plaintiffs committee want to take depositions, right? We want to go in and take the corporate representatives, the key opinion leaders of the companies, but at the same time, we're not going to do that unless we have all the documents that we need to question them on. So, on the one hand, it's, we want to move the case as fast as we can, and we could be taking depositions, but at the same time, do you really want to depose someone who you really only get one shot at, not having all of the relevant documents? And the answer to that is no. You never want to do that, because it's going to undervalue the case for all your clients. So, look, I think I agree with you. It's a strong case. I think it's a sleeper as far as the publicity of it goes. Ozempic is a much more sexier tort, just because so many more people use that drug. But it's a strong case, and I am very, very optimistic of it once we go through all these.
I really think they appeal to me, okay? Because I'll tell you what upsets me more about this than anything else when you really delve into it is if you look at your Paragard product, pull it out, look at the product, okay? It's essentially as complicated as a plastic paper clip with some metal wrapped around. I mean, it's really, if it costs $2 to manufacture, I would be shocked. Right, I mean, and they sell this product for anywhere from $400 to $1,000 to be inserted into a woman. And I'm sitting there going, like, look, if you're selling me a plastic paper clip for $400, it better be perfect. Right, because there is no, like, you're getting so much for this. Like, the cost to manufacture is zero. How are you not doing it right? Like, how are you not spending every dollar you can to make this product right? Because, I mean, it's literally like a little tea this big, right? I mean,
no
it's
drugs.
Tiny.
There's no drugs.
Yes. There's no drugs, so there's
it's
no
copper.
cost. I mean, it's like $2, right? And they sell them for $400. The Dalcon Shield, I remember looking into this a little bit, right? Costs 50 cents to manufacture. They sold it to the doctors for $4. Doctors sold it to the patients for 12. Okay, had a string hanging down that was supposedly shielded against bacteria, but what they didn't realize, they cut the top and bottom of the string, right, which allowed bacteria to enter, because that it jeopardized the shield on it. Look, the guy looks at this and says, "Oh, we can fix this. All you got to do is cauterize the ends of this string, and then the shield will be intact." Said it was going to cost too much, right? It's going to cost like another 5 cents or something like that, and they didn't do it. And it's like, when you look at the decision making behind this, you go, "How did you get there?" Like,
by the way, Stan, you listen to the same podcast I listen to. That was the podcast you turned me on to.
Yes.
The same exact one.
Swindle.
It was about, and it started with Dalton Shield.
Yeah, it's swindled, but I listened to it, and
Swindled.
you're like,
Not plugging swindled, but great podcast, and that's where I learned about it.
But you sit there and you find it to be offensive, right? So
Oh, God.
drugs, there's a lot of things here, but and they're complicated, right? When you show a jury a piece of plastic with some metal wrapped around it, nobody's going to have a lack of understanding. No one's going to sit here and say, "My God, look at this. This is a super complicated invention. I can't imagine how this gets built." Right? I don't know how a microchip works. I understand how an IUD works. It doesn't take very long. Right? So I think it's almost more offensive when something that is so simple to manufacture and so cheap to produce malfunctions in such a significant way, because it doesn't cost much more to make it better.
I think you answered your own question, right? It comes down to the almighty dollar. And that's it. But you're absolutely right. I would hope that if it's something as simple as a plastic and copper, and you're charging that much for it, it better be medical grade, not nothing below. And people would be shocked through the litigations that I've been involved in. If you look at you want to get really scare yourself. Next time you get a device put in you, or someone wants to put a device in you, ask your doctor, what are the materials? What are the components made of that are in there? Number one, your doctor's 99% of the chance they're not going to know. But there's a data sheet, an MSDS data sheet, which tells you what components, what type of plastic, what type of monofilament, where did they get it from? Costa Rica, Mexico, China. Where are they getting those components from? Are any of those components carcinogenic? Start asking those questions to your doctor. He or she probably won't know.
It's amazing. Yep. This goes back to, even the breast implant litigation. When you go back to Meme Implants and Dow Corning, like, the coverings they were using on these implants were industrial foams that were said, "Hey, you do not insert this into someone." No one even looked at it, right?
Sad.
This isn't a new concept, right? This has been going on for years and years and years. But the amount of money, the billions, we're not talking millions, we're talking billions with the B. Right? And you also got to look at the nature of this, right? A company is a company, but it's run by stockholders, right? Stockholders are making money on discrete events. They can get in and get out, right? They don't have to stay in. They can make money when the product sells, and they're out before the bad stuff happens. So it's not like us, where we're truly an organic being and we're going to have to live with our decisions, right? And they're going to be stuck with us forever. If I murder someone, right, I'm going to jail for 25 years. I can't ever just dip out of this body and go do something else. But the companies, right, no matter what they do, the individuals in the companies, they go on to something else. Like, if it goes down in a ball of flames, they move on with the big pot of money they got from doing it wrong in the first place.
They go to get jobs at the FDA.
Yes. So I wanted to end with first, thank you, Marcus, for coming on today and going over these two important projects. And I want to make a statement, and perhaps this statement will get edited out afterwards. And Marcus may or may not like what I'm about to say, but I'm still going to say it. What impressed me most about Marcus, and this is like a lesson for, hopefully there's some young lawyers listening to this podcast today, that you create your own opportunities in life. If you want something bad enough in life, you need to go out and kind of seize the moment and go get it, because no one's going to give that to you. And the lesson is, Marcus Susen, who went up to Pennsylvania to be on the steering committee in Ozempic, that was his goal. And when he went up there, he was told that, we basically have a slate, and maybe we'll try to get you a position, but who knows? And there's no guarantees. And Marcus had the cojones, the balls, if you will, to get up, stand up, approach the court, and ask to be on the steering committee, which may have upset some people, maybe not. And Marcus, we need to edit this part out. I will, because it may upset some people on there. But anybody who knows you likes you, so I can't imagine that would upset anyone, other than the fact that you had the balls and the audacity to go up there and ask for something that you deserve to be on. And what pissed me off most, and I'm friends with Marcus, is when I read some of the motions that came forth from other lawyers who wanted to be in the steering committee, and they called Marcus a young lawyer. First of all, you're not young. You've been practicing for almost 20 years. 2, you're board certified by the state of Florida as an experienced civil trial lawyer. And 3, while I'm not Marcus's champion, I'm not here to being his cheerleader, he was lead counsel on Eshore and resuscitated a mass tort that was dead and brought it was fruitful. And he was able to obtain compensation for a ton of victims who were very worthwhile victims, worthy victims. So Marcus has done some amazing work, and I'm very impressed, and I was amazed by the fact of what he did, pulled off, and the fact that now he's on the steering committee. And I got excited when I read Law 360 last week and saw he was one of 8 lawyers that were chosen by Judge Prater to be on and to champion this mass tort and push it forward. So kudos to Marcus Sussen. That's it. I got nothing else.
I appreciate those words. Just remember, let me leave you with this.
Yes.
I'll leave you with this. With Ozempic, Rybelsus, and semaglutide in general, it's a sexy topic. It's everywhere. All the celebrities, it's on social media. You're going to lose weight. You're going to lose weight. You're going to lose weight. Everyone needs to slow down. We need to, listen to your doctors. Make sure the FDA has all of the information, and ask those questions that we mentioned earlier. How long am I going to be on this for? Is my body going to have a tolerance to it where I have to go up and up and up? And then what's the max? And what happens if I come off of the drug? Obviously, we're not doctors here, so everyone's got to listen to their own doctor. But as a patient advocate, those are the questions that everyone needs to ask, instead of kind of getting blitzed by all of the glamour and Oprah and the social media. Important to ask questions.
Understood. Well, I appreciate you coming on today, making time for us. This was an awesome podcast. Thank you very much, Marcus, and thank you, Stan, as always. And this wraps up another episode of the David and Goliath podcast. If you're interested in pursuing a case against Ozempic, Mounjaro, Wegovy, Rybelsus, I hope I'm saying that correctly, and Trulicity, you can contact Marcus Sussen. You can call me. I'll put you in touch with Marcus. I refer my cases to Marcus. So if you call me and you hire Dolman Law Group, we're going to bring Marcus in on this case. But Marcus, how do individuals reach you directly?
Yeah, we make a great team with Dolman, and you can look me up online. Just Google Susen Law Group.
Marcus likes cell phone calls after midnight, usually between midnight and 4 a.m. He prefers you call a cell phone. So, Marcus, what number is that? Or just give us your office number. How do we reach you?
And the best is via email at marcus@susenlawgroup.com, SUSEN lawgroup.com.
Okay. Appreciate it, Marcus. Thank you for coming on. Again, Stan, thank you, and have a great day. Take care.
Always fun, Marcus. Thanks.
Thanks, Stan.
This episode of David vs. Goliath is over, but your journey is just getting started. To share your story with us, visit dolmanlaw.com. That's DOLMAN law.com, or call 866-965-6242. The insights and views presented in David vs. Goliath are for general information purposes only and should not be taken as legal advice for any individual case or situation. The information presented is not a substitute for consulting with an attorney, nor does tuning into this podcast constitute an attorney-client relationship of any kind. Any case result information provided on any portion of this podcast should not be understood as a promise of any particular result in a future case. Dolman Law Group. Big firm results, small firm personal attention.